Good morning, everyone. Welcome back to day 2 of the 21st National Tribal Preservation Conference. NATHPO 2021 is virtual. I see people doing this already, but please feel free to introduce yourself in the chat box so that everyone can see who's here. I'm sure people will be joining us as we jump in, but we're going to go ahead and do that so we can keep on schedule today like we did yesterday. I was really excited about that. Quick word for my tech support back here that you guys didn't see me. I hope that's fixed now. Our first session today is going to be best practices for THPOs, laws and landscapes. This was the best title that I could come up with for it. It's a really, really rich topic. And if you didn't meet Wes yesterday, I want to introduce 2 of our NATHPO associates. Dr. C. Timothy McKeown is the first speaker. He is retired from Department of the Interior and Park Service and serving pro bono as our repatriation advisor, or as he likes to say, Consigliere. He's a legal anthropologist with an extensive career in doing this work, and we are so gratified and glad that he is serving in this capacity for us and our members. Most of you probably met Wesley Furlong yesterday. He's a staff attorney at the Native American Rights Fund, and I'm glad to be able to call him our lawyer. He's always there for us. In fact, after the close of the conference yesterday, I sent him a request and he responded right away. You guys also met Lance Foster yesterday, who is the vice chair and the THPO for the Iowa Tribe of Kansas and Nebraska. And he's also been newly reelected to serve on the NATHPO board. We're going to run another couple of survey questions for you guys. And Tim's going to go first so he can let us know if he wants to kick off with the questions or if he wants to make some other comments first. But we're going to talk about NAGPRA and what your interests are in NATHPO supporting your needs on this. We're going to talk about laws affecting tribes and sort of make sure you guys have the legal foundation and understanding of that you need. And Lance is going to talk about landscapes, a topic that's near and dear to my own heart, and something that we plan to get a lot deeper into as the year goes on. So I'll turn it over to Tim.
Thanks, Valerie. Can I share my screen?
I think I need to make you a co-host. So let me do that. Sorry. Tim. Wow, a lot of participants again today. This is great. Who are you logged on as, Tim?
Should be me.
Valerie, he's under C. Timothy.
C. Thank you, Shasta. I still don't see you in my list.
Okay, that's a little one.
Okay. Sorry about this, guys. I really don't see you listed here. Oh, you're at the very top. Not under the T's or the C's. How's that?
Got it?
Perfect.
Okay. I want to thank Valerie, the board, and all of you for the opportunity to talk about my favorite topic, repatriation. I want to acknowledge first that I'm sitting in the traditional territory of the Nacotchtank, Anacostan, and Piscataway people. I'm going to be covering 4 things very quickly. Section 3 of NAGPRA dealing with inadvertent discoveries and planned excavations on federal or tribal land. Section 4 dealing with illegal trafficking of Native American cultural items. Section 7 dealing with repatriation of cultural items from museum and federal agency collections. And then lastly, the National Museum of the American Indian Act that deals with repatriation from NMAI, natural history and American history. I will be presenting an incredible amount of data very quickly. So if you would like a copy of the slides, just write to me at repatriation at nathpo.org and I'll send you that. Okay? It didn't advance. There we go. Okay, section 3 deals with ownership, is titled ownership in the statute. It requires federal land managers to take certain actions whenever Native American cultural items are inadvertently discovered on federal or tribal land, or when cultural items are anticipated. The primary data set, or the primary way to monitor this process in section 3 is through what's called notices of intended disposition, which are required after discovery or excavation and before disposition of the items to the appropriate tribes. Just the data that I'm doing here very quickly, the bottom line timeline shows that the number of notices published per year has varied, and that the majority of these has been published by bureaus of the Department of the Interior. The table in the upper left-hand corner shows that the number of cultural items involved is relatively small as compared to the number in museum and federal agency collections. And the table in the center shows that 3 departments have designated human remains or other cultural items that were excavated or discovered as unclaimed, which is something that's anticipated under the statute. And 2 of those have subsequently proceeded to either reinter the remains or to transfer them through some other mechanism. I think it's conspicuous that the one that has not done that is the Park Service. Section 4 of the statute is a criminal provision. It's implemented by the Department of Justice. It establishes criminal penalties for illegal trafficking of Native American cultural items. The timeline at the bottom shows data on all cases through 2016. The dark green and light green columns represent cases involving human remains and funerary objects. These occurred from 1995 onward through the end of the period that I have data, and they were filed in district courts all across the country. The yellow columns represent cases involving sacred objects and objects of cultural patrimony. These are limited to the period of 1993 to 2004. There are none after that date. And all of these were filed in either the district courts for New Mexico or for Arizona. There are none from any other districts. The one red dot there, red column, represents the single not guilty verdict in a case in Northern District of Illinois, where the defendant argued that the court couldn't prove the remains were Native American, and they relied on an argument similar to what was proposed in the Kennewick case by the Bonnickson plaintiffs. The gray columns represent NAGPRA cases that were opened and subsequently dismissed in court, usually as part of a plea deal on some other charges. The white columns represent NAGPRA cases that were opened by law enforcement but subsequently declined by DOJ, and there's a listing of the various types of declinations up here. The few convictions after 2007, along with the lack of any dismissals or declinations, indicate either that there's a significant change in the market which I don't believe is true, or that there's some shift in how these particular cases are being investigated and prosecuted, which I think probably is true. Section 7 deals with museums and federal agencies and requires them to repatriate cultural items in their collection to lineal descendants, Indian tribes, native Hawaiian organizations. The chart in the upper left reflects that most human remains are held by museums, not by federal agencies, and that federal agencies have made decisions to repatriate in about half the cases, whereas museum decisions to repatriate are less frequent. The upper right-hand corner shows grants funding availability from the beginning of the grants program in 1994 to this last year. One thing that you can notice from it is that up until 2015, there was sort of a regular administrative skim from the grants program that went to the program, and that after that, that skim has been reduced, primarily because I think the grant amount was reduced, and sort of that reduction was administratively moved over to a separate line. The lower left-hand quarter shows civil penalties that have been assessed against museums that failed to comply. Notice that there have been no civil penalties assessed since 2016. National Museum of the American Indian Act requires all Smithsonian museums to repatriate cultural items upon request from or upon a request from a cultural affiliated Indian tribe or Native Hawaiian organization. The left-hand chart shows the number of items repatriated by National Museum of the American Indian and National Museum of Natural History through 2019. The right-hand figure puts the number of human remains repatriated into a broader context of the total number of human remains held by NMAI and Natural History. These counts are approximate, given that some of the data was provided as catalog numbers and not as minimum number of individuals, but you can sort of get the general idea. The lower left-hand corner shows a timeline from 2011 on, showing the number of remains that were repatriated each year. Lastly, repatriation during the Trump administration. Section 3 provisions have primarily been used or been triggered by inadvertent discoveries. I think we need to motivate federal agencies to negotiate comprehensive agreements so that how the agency is going to behave is predetermined and that the tribes have input on how that is going to be done ahead of time. Section 4, the comprehensive data on trafficking for this period, for the Trump administration period, is not yet available. I actually have a FOIA request into that to DOJ. But anecdotally, seem to be infrequent and limited to cases involving human remains, as they have been since 2007. NAGPRA supports the STOP Act amendment to increase penalty amounts, but believes that that amending the statute to fix the Ninth Circuit interpretation of Native American, which I think has put a chilling effect on the prosecution of these, and refocusing enforcement priorities more to the model that was used in the early period by the ARPA task force and other groups in the Southwest is necessary. Section 7, I believe the National NAGPRA program seemed to have abandoned the review committee. There's been no meetings for the last 15 months. The committee's request to consult regarding proposed regulation rewrite was denied. The committee's report for FY 2019 to Congress, I don't believe has been sent. There's also been no program report published since 2018 and no civil penalties assessed since 2016. There is an amendment that was in play at the end of the last session. In September 2020, Representative Holland introduced HR 8298 to do a number of things: revise the civil penalty provisions and increase penalties, reassess the Secretary's enforcement and other delegations to the Office of the Assistant Secretary for Indian Affairs and identify NAGPRA information as confidential and not subject to public disclosure. Under the NMAI Act, in terms of progress, repatriation progress seems to be very modest, to put it kindly, given the nearly 13,000 Native American human remains yet to be addressed. In October 2020, Natural History issued a new policy regarding return of culturally unaffiliated human remains and funerary objects. And lastly, NATHPO has proposed language to amend the NMAI Act to give U.S. district courts jurisdiction over allegations of violations of the Act. And this, I believe, was at the request of a particular tribe that is involved with the issue there. Lastly, again, the repatriation@nathpo.org email address if you would like a copy of the slides or if you have any repatriation issues that NATHPO needs to address. That's it. Thanks.
Thank you, Tim. That was a great overview, and that was indeed a lot of data in a short amount of time. Well done there, and I'm sure people will want to continue to look at that at their leisure. So maybe we can try to get that posted on our website in addition to the conference recording. Thank you so much for serving us and our members in your capacity. We are really grateful to you for that. I'm going to make Wes a co-host as well, and Lance, so that they have all the privileges thereof, and turn it over to Wes to talk about laws. Hope you guys got your refill going. We're diving right in this morning.
Oh, good morning. Thank you, Valerie. As Valerie said, my name is Wes Furlong. I'm a staff attorney with the Native American Rights Fund in Anchorage, Alaska, which is part of the traditional homeland of the Dena'ina Athabascan people. Valerie asked me to give an overview of some of the laws and that tribes and THPOs have to deal with, particularly in the context of cultural resource protection and management. And with Lance's upcoming talk about cultural landscapes, I decided to focus on probably, I think, arguably the most important cultural resource statute that THPOs deal with and tribes deal with, and certainly I deal with in my practice, the NHPA, and particularly to talk about, I think, some of its shortcomings, opportunities to be, opportunities for tribes and THPOs to work creatively within the constraints of the NHPA, and sort of also discuss the legal basis for why cultural landscapes need to be recognized and considered in the Section 106 process and within the NHPA more broadly. I certainly think that the NHPA is probably the best statute that tribes have to protect their cultural resources in places of cultural significance. In particular, the Section 106 process provides tribes with what should be a meaningful and powerful role in protecting those resources. And that strength comes from the consultation requirement within the statute and the Advisory Council's regulations. I say that, and of course, I think everyone's experience is that that's not necessarily the case. You know, the NHPA Section 106 and the statutes that tribes and THPOs deal with seem to always fall short of their promise and their potential to protect these places. And I doubt that anyone in here, anyone attending this conference has ever had, has never had a bad experience with the NHPA or felt that it was always perfect. You know, I think it is the strongest statute that tribes have to protect these places. But again, I think it does fall incredibly short. And I think there is a real need for a new approach at the federal level to protect these places and these resources. Because I think the NHPA unfortunately doesn't go far enough. And the role that it provides tribes, well, I think is important and provides them with a lot of with a strong ability to protect these places is not enough, and the consultation requirement isn't enough, and the fact that the NHPA doesn't provide substantive protections for these places is an inherent flaw. So, you know, while I say it's the best statute that we have, I think it does fall far short, and there is an incredibly important need to find to have better laws. Unfortunately, until then, we're stuck with what we have, and we have to come up with creative ways to protect these places within the existing laws that we have, because those are the only things that are going to be, you know, when we're dealing with federal agencies, they're not going to be, they're bound by what these statutes require and mandate. So we have to find creative ways within these statutes to advance indigenous understandings of cultural resource stewardship, and to ensure that these places are protected in a way that reflects how tribes want them to be protected. And I think there's an opportunity, there's certainly opportunities to do that within the NHPA, and particularly in looking at and trying to protect and recognize cultural landscapes. I know this has been my personal experience in representing tribes, and I'm sure it's probably almost everyone else's experience here who's attempted to have federal agencies consider and look at cultural landscapes within Section 106 processes. Is the common refrain that these things don't exist, or that the NHPA doesn't recognize them, and that there's no legal basis for their consideration in these processes. I think certainly everyone here is it's not a I think we all know, you know, as practitioners, as attorneys who work in this, as tribal members, as THPOs, as culture bearers for tribes, and we certainly know that cultural landscapes exist, and we can see them, you know, everywhere we go. But particularly for dealing with federal agencies, not only is it forcing them to you know, come to terms with the fact that cultural landscapes exist as an actual thing, but it's also forcing them to recognize that within the National Historic Preservation Acts, they have to consider these resources, and that there's a good legal foundation for doing that. And you know, I certainly come for this. I certainly come from this from the perspective of an attorney and as an advocate for my tribal clients. So, you know, dealing with the laws is sort of where I fall. But I think it's important, you know, for practitioners and THPOs and people engaged in this to understand sort of the legal basis for recognizing and considering cultural landscapes in the Section 106 process, and more broadly within the NHPA, because this is, you know, in my experience, agencies, federal agencies, developers, and industry, and to a degree, SHPOs and state governments, you know, will sometimes flatly refuse to acknowledge that these resources can be considered in these processes. So I kind of wanted to go briefly over, briefly go over some of the very foundational guidance that sets the groundwork for recognizing these places within the NHPA, and then I think turn it over to Lance to have a more substantive conversation about cultural landscapes outside the legal context, because it gets a little wonky talking about agency policy. But essentially, you know, under the NHPA, we have two agencies that are really driving the conversation and have authority under the Act. We have the Park Service and the Advisory Council. And the Park Service, you know, we rely on the Park Service's guidance and their National Register bulletins to discuss, you know, the recognition of cultural landscapes within the NHPA, because obviously to consider them in the Section 106 process, they need to be an eligible historic property. And so there's a number of resources the Park Service has to that provide the basis for recognizing cultural landscapes. You know, particularly Bulletin 38 and its discussion about traditional cultural properties, explicitly within that recognizes that TCPs may often encompass landscapes. and may exist at a landscape level, and that these resources can oftentimes expand beyond a discrete site and encompass a far broader area. Preservation Brief 36 discusses cultural landscapes, and within that, ethnographic landscapes. And I really don't like that term, but that's the one that the Park Service uses, so we're sort of stuck for now using it. But that certainly, with Preservation Brief 36, it recognizes cultural landscapes as a very valid and existing type of historic property that is required to be considered, and within that, one specific type that I think is particularly important for our conversation is ethnographic landscapes. And then I think, this is something that, people who work in tribal cultural resources might not necessarily turn to this, but Bulletin 30, which is also by the Park Service, which discusses rural historic landscapes, is also an important resource, and I think can be turned to. I've certainly turned to it with agencies as another basis for why they need to consider cultural landscapes when dealing with tribes. Rural historic landscapes tend to often be farming districts in rural America, but the definition is broader than that and includes, I'll just read the definition: a geographic area that historically has been used by people or shaped or modified by human activity, and that possesses a significant concentration, linkage, or continuity of areas of land use, vegetation, buildings and structures, roadways and waters, and natural features. And one of the other things that Bulletin 30 recognizes that these landscapes have been shaped by cultural and natural forces. So there's nothing in them that requires there to be sort of a built environment that contributes to it, as I think they traditionally are considered. But these, and then beyond that, there's the Park Service has its cultural landscape characteristics or criteria for how it characterizes its own landscapes within the Park Service units. And I think the totality of these guidances within the Park Service can serve tribes and THPOs really well in discussing cultural landscapes in a language that federal agencies should understand, and that they can't ignore because it's rooted within agency guidance and policy. And I really I cringe at saying that, because tribes shouldn't have to be relying on the Park Service's guidance and the Park Service's understanding of cultural resources in order to discuss their own cultural resources and their own cultural landscapes. But with rare exception, I found that federal agencies don't give a lot of credence to what tribes say about their own resources. And I found in my experience, we're forced to talk about these places and these concepts in languages that the agency understands. And it's it's disheartening and frustrating. But when we have these conversations in agency guidance and we discuss them in the context of the National Register bulletins, it seems like federal agencies care a little bit more, or at least are able to understand them. And I think this speaks to broader issues within cultural resource management and protection within the federal government. But this is where we're at. And beyond the Park Service, we also have the Advisory Council, which has spent a lot of time discussing cultural landscapes and the need to consider them in the Section 106 process. And it's their guidance is pretty simple. Federal agencies have to consider cultural landscapes in the Section 106 process, and that's been the policy. That's been the policy and guidance of the Advisory Council for a number of years, and consistent guidance. Despite that, federal agencies still refuse to consider these places within Section 106 processes. You still see tribes battling it out with the Park Service. I think this is mostly to do with the previous administration, but the Park Service and THPOs in nominating these places to the National Register, and a lot of pushback from industry and private individuals and landowners who view tribes' efforts to protect these places as beyond the scope of what the federal law protects. And that's just simply not true. There's plenty of legal basis for tribes to be pushing for this beyond this, the cultural and moral reasons for doing so. I think the last thing that I want to touch on, because I think, you know, sort of based on some of the discussions that I was sitting in on and watching from yesterday, is who has to take responsibility for doing this work, particularly in the Section 106 process. You know, we all understand that it's the federal agency's obligation to do to engage in Section 106, to go through the steps to do the identification of historic properties, and to take responsibility for those actions. But I think we often find that when we're dealing with, in particular, cultural landscapes and TCPs, federal agencies, they want to ignore them because they don't. They either don't believe that they're types of historic properties that actually exist or that are worthy of being considered, or they're afraid of having to figure out how to resolve adverse effects to cultural landscapes or TCPs. And so the results is that agencies just ignore them in the process and refuse to consider them. And so it then falls on tribes to have to do the work of the agency in providing the documentation within a Section 106 process to recognize these places and basically force the agency to do its job. And I've advised a lot of tribes in 106 processes where the agencies have flatly refused to even acknowledge that cultural landscapes exist, despite repeated efforts from tribes to get them to do so. And the onus has always fallen on my clients and these tribes to do all the work. And that's both good and bad. I mean, on one hand, it's bad because it's the federal agency's job to do it. And often my clients, particularly up here in Alaska, don't have cultural resource departments, don't have the means or funds or resources to be able to engage in these documentation efforts for large cultural landscapes that can often be very resource intensive to pull together the documentation necessary to ensure that they are determined eligible. So it's bad on one hand, but it's also good on the other hand because it ensures that the tribe's in the driver's seat about in determining what's important about these cultural landscapes, the types of contributing resources that are important to the tribes. And there's a real tension between the two because on one hand, the federal agency is shirking its responsibility, but on the other, the tribe is the one that gets to define why these places are important, what's important about them, and drive the narrative in the conversation about these cultural landscapes with the federal agency. And I think that's on that side of the coin, that's a very good thing because I personally don't trust federal agencies to be in the lead in these discussions about why cultural landscapes are important because they're not, they're going to fall back and on, criterion B and say, well, there's archaeological resources there that have the potential to inform us about the past. Therefore, this place is important. And that, I think obviously those things are important, but it misses the broader point. And I cringe at seeing federal agencies' attempts to discuss why cultural landscapes are important to tribes outside that context, because it tends to be very patronizing or it misses the really important parts. And they just don't have the knowledge or understanding to really have that to be discussing those things. So unfortunately, I think we're stuck with statutes that fall far short of where I think we should be, and I think most tribes think we should be in terms of protecting these resources. We engage, our clients engage in these processes for years, and at the end of the day, there's the agency gets to make a decision, and there's no real substantive protections other than process. and it's incredibly frustrating. And I think there needs to be, I think there needs to be a total reorganization of how we do this, and that probably requires new statutes, and that comes with its own problems. But until then, we have these statutes that we have to deal with, and I think there are creative ways for tribes to push for and advocate for better, more indigenous-led stewardship of cultural resources. And the resources are out there. There's plenty of examples of this happening, of tribes doing this, of these places being recognized and protected. But they can sometimes feel like they're few and far between, and often it feels like we're trying to fit a square peg into a round hole, because the statutes, these regulations were not envisioned for tribes and these types of resources. So it's always an uphill struggle. But at the end of the day, there are the resources, and it unfortunately, or fortunately, depending on your perspective, falls on the tribes to really think about this creatively and use the resources they have in a way that we haven't necessarily done in the past, or agencies are not used to having dealt with in the past, to force the conversations that tribes want to have about these resources. So I'll leave it there for now, and turn it over to Lance, and then maybe we'll have a minute or two for some questions at the end. But I do have a link. I do have a list of some of these resources. And I will make sure to post that in the chat after I'm done, and then maybe if that doesn't work for some people, maybe figure out a way of getting it out to people so they can see where some of these resources are at.
Thank you, Wes. Wow, this is a very stimulating discussion, touching by the chat box here. I just want to say again that this is a major topic that we plan to dive a lot deeper into this year. And I am really loving all the specific experiences and thoughts that you're sharing here. So I look forward to having this as a much longer standalone discussion with all of you. Thanks, Wes. It was also a lot of material in a short amount of time. So well done. And we will turn it over to Lance.
Okay, I am unmuting myself, and I am trying to share the screen. Share desktop. Oh, no, it's saying I have to do a firewall crap. Let's see. Privacy.
Do you want to email it to me and I can share?
Yeah, why don't we do that? Let's see, I'll close it so I can email it to you. Let's see here. Once upon a time when I was young, I knew how to do this stuff very fast.
Mm-hmm.
Now my brain is old and tired, and the pandemic has made me older and tireder.
It's always harder when there's
I sometimes want to talk to people instead of having all this goo-gaw that you have to put with it. So, but it will help people. So I want to go plus to Valerie. Come on, Valerie, get up there.
Grusing, not Hauser. You haven't done that, but
now one thing to realize, I'm going to have to export it to a PowerPoint because this is on Keystone. Do you have Keystone? Keynote, sorry, Keynote.
Oh, no.
Okay. So.
Lance, I have Keynote. This is Shasta, if you'd like to send it to me.
Okay, I'll send it to you.
So I'll just have to boot it up on my Mac real quick.
Why don't we take one of the questions in the chat box?
Yeah, please do.
So that take a little pressure off Lance. It's always harder to do that stuff when there's a few hundred people watching you.
It's okay. I pretend there's only one.
Let's see. Okay, a question came in early from Michael Kickingbear. For Wes, some agencies have begun to use a substitution process of Section 106 to the NEPA process. Should tribes request that agencies use both processes for reviews?
Man, NEPA substitution. I'm fortunate enough to not have to have worked on an undertaking that the agencies opted to use NEPA substitution. This is my jaded view, my cynical view. I tend to, my like knee-jerk reaction is if an agency is discussing NEPA substitution for 106, that they're trying to circumvent, they're trying to find a way to circumvent their 106 obligations. I'm sure the folks at the advisory council would disagree with me, but I do have concerns with it. Maybe in this administration, those concerns might go away a little bit, but I think we already see a attempt by agencies to streamline 106 streamline 106 as much as possible to the detriment of tribal interests. So I tend to see it as not necessarily the greatest, but I personally haven't had to deal with it yet. So those are my sort of just jaded and cynical views of it.
And Dr. Langley had asked, can we please post the links to all of the items that you listed, Wes, on the website? So I will add that to my list to do.
Okay, we're just about ready to go. It's just opening on my Mac. And Val, I'm logged on as you on my Mac, so y'all don't get confused if you see there's two Valeries.
There are, but it's not you.
Let me see. So let me play the show. And oh, God dang it! Technology is just never as easy as you want it to be, is it?
And if it doesn't open up, I can wing it. I can draw pictures in the sky for people.
Draw pictures in the sky.
In their minds.
This is great. Yeah, just start talking, Lance, and when I get there,
right.
You can just,
Okay. So imagine, if you will. So this is about tribal cultural landscapes, and specifically shifting the paradigm on ways to do CRM to include landscapes. My background, so kind of where I'm coming from, my experiences with it. So I went to school at IAIA and the University of Montana, where I got the first minor in Native American Studies there under Dr. Henrietta Mann, and my major in Anthro in '84. I went to grad school at Iowa State with my MA in anthropology, and then got a master's in landscape architecture, specifically in historic landscapes from '94 to '97. And I had work experiences from the 1980s through 2000s, including being a shovel bum all over the place, a Forest Service archaeologist in Montana, which is kind of what got me going with landscapes, because there's a road. On one side, they have a historic mill. On the other side, they have the cabin where the guys worked in the mill, and they're calling two different archaeological sites. So I'm thinking, how stupid is that? So I had conflicts, obviously, with bureaucracy. Historic landscape architect for about 4 years in the NPS Cultural Landscapes program in the Intermountain area, mainly the Southwest and Alaska. And then I was a director of Native Rights, Land and Culture at the Office of Hawaiian Affairs. And then finally, I've been the THPO for the Iowa tribe since 2013 and elected VC in the fall of 2019.
All right, we got your screen up. Yep, we got your screen up. So just let me know when you want me to advance.
Okay, what I want you to do is go to THPO tank. That would be slide 3. It's got a picture of Dory and the gang there. Way up.
I'm scrolling through. It's not letting me.
It's way up.
Okay.
There we go. Well, that's the last one.
Yeah, so slide 3. Hold on. There we go.
There we go.
Okay.
So, as we all have heard and we all know, the NHPA is the funded reason to exist. Section 106, all that stuff, right? So our tribes sometimes do add other duties to us as THPOs, sometimes NAGPRA, sometimes culture, sometimes advocacy. But the reality is that good old NHPA is the aquarium we all swim in. And yet we realize there's an entire ocean beyond, but we're stuck in these little glass walls, right? So the laws that we work with under NHPA, you got to realize the first thing, it's like playing any game. And in this case, Monopoly does seem appropriate. You have to learn the rules, the parameters of playing the game. For example, the evaluation under Section 106, etc., in connection to the National Register of Historic Places include things like effects, eligibility, integrity, and so on. And depending upon your territory size, like my tribe, about 9 different states that we can tie to specifically archaeologically, not even just traditions, but specifically archaeologically. This can bury a small one-person THPO office like myself, for example, and you're buried by dozens of agencies and everything. Plus, there's a bonus. Wait, this listing, if you actually get there, doesn't really protect your sites for good anyways. It just kind of slows things down, can make things a little more difficult for them. Really nothing sacred. It's not part of the worldview there. Maybe Arlington Cemetery might be, but not even the Statue of Liberty, because if you went through the process, you could tear down the Statue of Liberty. It's just a process. It's not saving anything. Now, evaluation. When you do that, there's often confusion between condition and integrity. They say it has no integrity because it's worn down, there's nothing there or whatever. No, as long as there's enough there to tell the story of the historic context, it has integrity. Condition is where something's worn down. Think about it this way. If you have a mining site, and on one mining site you have a perfectly preserved head frame, and there's like an ocean of modern houses around it, versus a place where the head frame's fallen down, there's some junk there, a couple rotten logs. The second one has integrity. The first one has a condition of one of the elements. On historic context, we always focus on the national context. That's the one the law focuses on. The state, but there's also local. Nobody really looks at local context. Nobody, and specifically tribal context. Now, you whether want to call tribal as a type of national or a local or community, those are all levels needed under the National Register. People don't evaluate things based upon tribal historic context because nobody ever develops those really. So who has time, right? With all this stuff that's thrown at us, piles of stuff. How do you evaluate a tribal place without a tribal context? That's this whole thing about eligibility and everything, unless there's a good context, you cannot evaluate it. Let's look at cultural landscapes for a minute, because I worked on those for many years. The NPS Cultural Landscapes program is an established model. Actually, it kind of started being developed in the 70s and 80s. And really, it kind of came into its own in the 90s. But people still have problems with it, as you've heard. Agencies don't get it. They don't like it. It's a pain. They don't even like doing the archaeology stuff, really. When I was doing archaeology, they called us stones and bones and obstructionists. So they don't like that either anyway. But it is a useful approach. There's a way to use these tools to work toward what you want to do. And TCP itself, Bulletin 38, now actually going back for a minute, under vernacular landscapes, which we'll talk about in a minute, I worked with Tim Keller, he and his wife Genevieve were the ones that developed Bulletin 30. And we'll talk about those 4 types. I kind of wrote some notes. And I talked a lot about the ethnographic, but there are 4 types. There's historic sites like George Washington slept here, or the Battle of Gettysburg. There are designs sites, certain formal places like Central Park in New York is a design, but designed by landscape architects is what they mean, professionally designed. There's vernacular, which is what the rural historic ones come under, which is basically all the landscapes we do if you're not a professional, those are vernacular landscapes. The farms, your neighborhood, working neighborhoods, whatever, they're all vernacular landscapes. And then finally ethnographic, which is usually those other guys, that's us or black folks or whoever else. But also it means like the the people Chicanos or Chinese or whoever, you know, so it's always those other guys. Although it could be Polish Americans specifically too, but just what ethnographic group. But a TCP was a workaround for places that were considered significant to us, to average people, but they didn't have those archaeological or structural buildings, remains that archaeologists and architectural historians or the mainstay employees of CRM NHPA compliance programs recognize. Archaeologists, I was one and have been one and still on a certain level am one. They have their limitations. They do what they do well, but it's a one aspect. And usually most of these programs, whether it's the Forest Service or BLM or whatever, they have one position. Who do they hire? They hire an archaeologist. So what do you get? People who see archaeology and don't see anything if it's not archaeology. Cultural landscapes focus on analysis of all the parts of the landscape and how they work together, how it's all connected. So also remember that TCPs and cultural landscapes are not National Register categories. That's where people run into problems. The categories are when you put something eligible or evaluate it, it's either as a site or a district. So generally, landscapes are going to be districts. That's what you have to consider. But a cultural landscape filter or lens is a way to look at a district, all these different parts in it, right? The cultural landscape, again, is an approach to the interconnectedness of a place, both the natural, yes, animals, plants are part of that, and the human aspects, and how we use the land, how we move upon the land, it's all part of it. Physical and non-physical. To us, non-physical too. But you got to remember, with the National Register, it's all about managing material properties. You might be thinking like some of my friends in Zuni told me about that path between, you know, the Sandia and the National Monument there. But if it's not something they can see or manage or call physical in that materialist way, it's off the table for them. And also remember, these guys, is it a site or is it a district? Is it that point on a hill, or is it all the points on the landscape that you can see that distant hill over there where the sun rises and sets, right? What are the boundaries? And that's where you end up fighting all the time, boundaries, right? We'll get back to that in a moment. It was mentioned about one of the hallmarks of the cultural landscape approach model, way to begin to describe it and analyze it using the National Park Service model, are those lucky 13 landscape characteristics. And it's hard to see, I know, but I'll listen to you. Spatial organization, cultural traditions, cluster arrangement, how things are set upon the land in relationship to each other, constructed water features, not the natural ones, the constructed ones, land use, and this is key for us, that relates to TCPs, continuing land use in a traditional way. Topography, the slopes, the aspects, buildings and structures, archaeological sites are only one part of it. Natural systems and features, that's where you get into the environment and the ecosystems. Circulation, how people, animals, water runs through a landscape. Vegetation, all the species there, and you can include animals as well. Views and vistas, the difference is a view is a particular linear point to a mountaintop or a feature, a cleft in a valley, and a vista is that sweeping view from a top of a mountain or on the plains. You know, there's a high point up there by Pipestone up on the Coteau de Prairie, and it's like a hub of a wheel, and you can see 360 degrees around you. That's part of the vista. And small scale features, that's those small things in the landscape, maybe a stone, maybe a petroglyph, maybe something that makes it connected in a small way to what's going on there as a larger site. A good place, and we don't have time today, we will try to develop something for NATHPO and with NATHPO, but there's a site there, and I'll make this available as some sort of thing you can download as a PDF or something. But right there, we'll get you started. And we'll talk about training after a bit. Let's talk a minute or two about TCPs. That's a like a cultural landscape, it's a type of a place, could be a site or a district. Talked a little bit about the Bolton 38, partly because bureaucrats, agency archaeologists, architects, line authority, even if they know nothing about culture, the ACHP and National Register denied places with no buildings, archaeological sites, whatever. There's this place with some sacred plants and stuff there that's not a site because it isn't what they considered human made elements there. But the fact is, it's a landscape, it's a traditional cultural, they say property, we don't like the word property, we say place now sometimes, that they can be legendary sites, you know, maybe part of an organ or part of a body of one of the monsters or something might be on the landscape and you see it as a butte or something. That's all part of that. Realize a place can be both a cultural landscape and a TCP. But realize if you're going to go with the National Register route, you're going to have to decide is it a district or a site. And remember, it's not just tribal. It's not like segregating us. So it's the Indian stuff. It's other groups. It can be Japanese Americans have a TCP. You know, it could be any group. Polish Americans, whoever. It can be any groups can have TCPs. Now, this is the part that I struggle with you guys sometimes because I get a lot of people who get really their hopes built up and make it a TCP. Again, there's no special status in it. It's just another way to kind of grapple with what you see on the land. It all goes under that National Register. And so it has no special status like you're in the World of Warcraft, not a divine shield of protection. It's still a district, a site. Nothing is totally protected, as we saw with the Statue of Liberty. You go through the various processes, it can all be torn down, pumped dry, whatever, because the society doesn't see things that way. It just doesn't. It's not there. It lost that. It had it once.
Lance, that's a self-portrait, right?
Which, oh, no, I took that from some, you know, me, real easy ripping off of, no, I like the game. I used to play Dungeons and Dragons, but I was too old for the World of Warcraft, so anyway. So it usually it's a district, cultural landscapes. And this is the part, like I said earlier, you're going to have to fight all the time over boundaries. They want to shrink it as much as they can. Like over here, there's the road. That's not a site. Here, right around that cabin. Yeah, never mind the garden. Never mind where they got the water. Never mind that. This is the site right there. And right over there, that's a totally different site number right over there. Because they want to be able to do what they want to do. Manage it how they want. Pump it how they want. Put a well in here or there, whatever they want to do. So we want to make the connections because that's how we see life. And they want to manage it and switch it into a box. Here's that good old Venn diagram. It's always so useful for so many things. There's overlap, but they're not the same thing, right? So Native and Euro-American ways of talking about space, place and space are sometimes mutually exclusive, totally different, and sometimes there's overlap. And remember, this game we're playing called NHPA in section 106, all that stuff, even TCP as a category, it's based on white man laws. It is. And they're also based on session treaties, which were drawn by white government, like the Royce session maps. And just realize sometimes it's not just the Indian or white point of view of things. Tribes also have different points of view. We don't always agree with each other. We have different stories. It's not always comparable. Sometimes we like to compare so we can see where the overlap is, but it doesn't always overlap. And even within the same tribes, some different societies and things have totally different histories. Clans have different histories. And again, you know, the idea of the timeless Indian is where it comes from. There have been changes over time, migrations, conflicts, pushes, removals. There are different zones sometimes. There is a core zone recognized as our land, our village. This is ours. This is the multiple use or contested areas. And then we know we're across that river or that mountain range. That's those other guys' territory. We know these things, and those do change over time. People get wiped out by epidemics. There are droughts. There are things that happen. So there's always fluctuation, right? There's not this hardcore lines. That's a white man's way of looking at things too. We recognize the boundaries, but it's not historically, there's no a good historical context there. It is good to compare and learn from each other. both other tribes and from non-tribal people. But understand, even though we may not always agree, and we should always hold our own view, it's about multivocality, many voices, many stories. So here, this is where I want to shade these last couple slides into something that is totally a different focus. Eligible has been the focus. That's the NHPA, but we have to operate there. That's our rules on the board, or monopoly board. But why do we have to stop there? What is our goal? Not just doing the blah, blah, blah to get through the bureaucracy and stamp some papers. What are our goals as sovereign nations? Is education of our youth, passing on the traditions, restoration of the land, regeneration of the land, more likely, practices, continuing practices. Remember, land use under cultural landscapes and TCPs supports integrity both as a landscape, and you're using their own laws on that. A tool overlooked, it's in our mandate as THPOs to develop our own tribal registries. You can use the National Register, nothing wrong with that, but develop your own register. That's vital. You can use the National Register as a basis, or as for the different criteria, you can come up with your own. If you think them well out and are defensible in some way, because you're going to have to defend them all the time. Finally, and there's good old Dory, realizing there's a world beyond the aquarium, saying, wow, okay. So therefore, again, think about your own tribal register of place. It's important in your history and traditions, your own tribal context from your own tribal historians, as a way to assert your own view, teach your children, and face the legal issues of NHPA, NAGPRA, etc. There are overlaps of tribal interests in National Register programs and laws, but they are not the same thing. THPO, we act as a SHPO within the boundaries of our reservation outside, yeah, but so much more. It depends on your tribe, what they want you to do. Remember, there's an ocean outside your aquarium. That's it.
Sorry, Lance, for some reason your Dory graphic did not show up in the share, but
just imagine, here's Dory looking at that big current out there. She's kind of sitting there in the grass, you know, and there's that big limitless ocean darkness beyond. And she's saying, oh, I need to go out there, I guess. So yeah, that's Dory.
There's been a lot of requests to share your presentation, and I think you said that you would share it. So I'm going to convert this to a PDF, and I will just throw it into the chat. Just everybody give me a few minutes to work magic on my MacBook, which I'm really glad I ended up bringing to the office today.
All right, that was wonderful, Lance. Yeah, I can see from the chat box and speak for myself, say that we're pretty enthralled by that, and very much looking forward to making a deeper dive into this topic throughout the year, and also to be honest, pushing NPS on what can be done differently in a new administration. I think with a new Secretary of the Interior, these are conversations that we can have anew and talk about it from our perspective and our wish list. I see that Samuel Fayant has raised a hand, and I have unmuted him. A procedural point: we have a 60-minute break after this with a video to show. I'm going to make a note about the video. We're having a change of plans on that, but we can go ahead and have some discussion here for a little bit longer. Samuel.
Yeah, good morning, everybody. I'm sorry I can't get on the video here, but thank you, Lance. You know, think about, you know, I'm from, excuse me, let me backtrack here. I am from Southern Arizona, and the issue we're dealing with is the border wall. And even though we have like ancestral lands that stretch down into Mexico, and we still have relatives that live in Mexico, as a result of the wall being constructed down in the east and west of our now reservation, and because of the past administration's issue with, I would think their paranoia about, you know, issues concerning the wall, that they disregarded all the laws pertaining to environmental issues, culture issues, and so forth. And as a result of that, they desecrated some of the burial sites on Aboriginal lands. And unfortunately, they had to come to that, even though our tribal chairman and our legislative council, protest against, sent letters, etc., it still happened. And even the archaeologists that came in and surveyed areas and showed the construction firm that was doing the archaeology clearances on the border wall, they came in and did their work. And then they come back later and say, oh, well, we didn't know about this, even though they knew months ahead of time that these issues were there, the sites were there, et cetera, et cetera. So I just wanted to point that out to you too.
Yeah,
So
that is what they do. They go ahead and do what they want, and then ask for permission afterwards, because there's an old dictum in agencies: easier to ask for forgiveness than permission. So they just do what they want to do, and that's how it works. I had the good fortune and sad fortune, it seems to be, to have visited Quito down at Oregon Pipe and seen that sacred spring, that was right there as a crossing point for so many ages for the people down there. And that was just a shocking thing. We did a cultural landscape inventory there, and it was a cultural landscape. But if you got people who flout the laws, as we've seen them do, to their own, well, I'm not going to get political, but you saw it.
yes, sir.
Then there you have it.
Yeah, thank you. And I'd just like to touch on the NAGPRA real quick again. We are in the process of repatriating artifacts from the American Museum of Natural History, New York. A guy by the name of Carl Lumhos came to our area back in 1909, 1910, and bought a lot of the artifacts from them living out here and transported them to New York, and that's where they are. And my contact there was a lady by the name of Nell Murphy, who's in charge of the Natural Resources Department. And we had created a good relationship, And one of the things that happened under the NAGPRA is that there's a section in there that says we can submit a grant, and we worked together and applied for the grant, and we sent a group of medicine people and some people from the different communities here, and went to go do a blessing for the artifacts. Because again, we say that the scientific community sees artifacts as being objects, We see them as being part of the person. Whoever used artifacts, it's them. So to bring them back, it's bringing the person back home. And again, I just want to share that with you. So thank you. Thank you for your time.
Thank you.
Everett has his hand up, and Valerie, you were muted, so I'm not sure if that's what you were saying. But but Everett, if you'd like to go ahead, and I'm gonna pin you on the video too, just because you're so cute.
Oh, thank you. It's what I always wanted. So I just really wanted to add something before we moved on with the program. Wes was asked about NHPA being used, NEPA being used to substitute NHPA, and I wanted to mention something. EPA has a significant problem with forgetting something. NEPA has categorical exclusions. For example, if you're in a Superfund site, you don't have to conduct NEPA, end of story. You still have to conduct NHPA. And a lot of federal agencies do not know that. For example, almost every single EPA region does not realize that. The Quapaw Nation has had to threaten in the past, under our previous administration, 2 different EPA regions with lawsuits. And in the process of doing that, they brought in their lawyers, regional lawyers who disagreed with us. And then we threatened to go to litigation, and they brought in their lawyers from DC who quickly realized that we were right. And they had made EPA back off, and we had to get mitigation done for all the number of activities that have been conducted mistakenly that were considered exclusions, because exclusions do not exist in an NHPA. And I just wanted to make that clear for all tribes on the call, especially if you have a Superfund site. Do not presume that federal undertakings will be presented to you in the normal legal fashion, because federal agencies do not understand NHPA as well as they think they do. Quite often, they only know a little bit about NEPA, and they think that categorical exclusions exist. Because they do exist in NEPA, they do not exist in NHPA. And I just wanted to make that really clear for tribal representatives who may not realize this themselves, because perhaps they've just landed in a position and they're trying to learn all this and they don't realize that we don't have categorical exclusions. And even if they're doing a Superfund cleanup, they still have to tell you. I just wanted to make sure that was clear.
Thanks, Everett. We're going to take one more question and wrap the session up. And again, remind you that this will be a major topic for NATHPO later in the year. So stay tuned for a virtual workshop, seminar, symposium on landscapes. Can my team help me find one more question here? Linda wants to know, can we do an audience survey of how many tribes already have or are working on their own tribal register? That would be good for the session after the break. That's one of the topics. So be sure and come back for that if you take a break. Putting Shasta on the spot there.
Wait, putting me on the spot for what?
A survey question at the beginning.
Oh, right. Yes, I can. Yeah, sorry, Linda. I can't do a survey on the fly, but I can add one for
Well, we're
later.
talking about registers. Well, THPOs are talking about registers in the next session. Alrighty, not seeing a specific question or a hand raised. Let's just put a pin in all of this discussion for a later date. This was great, you guys. It's been so, I've really enjoyed seeing everything you've had to say about this in the chat box.